Hello everyone, welcome to India4IAS. My name is Shreyas. In this video, we'll be discussing about the Polity UPSC Prelims PYQs of the year 2020. So, from so many years, we keep on hearing from toppers about the importance of PYQs in Prelims. Prelims alli PYQ importance ಅನ್ನೋದು ಪ್ರತಿಯೊಂದು ಟಾಪರ್ ಹೇಳ್ತಾರೆ. So, if we have a good control over the PYQs, then we can actually get good marks in the real exam when we are giving. So PYQs importance yake? See, one thing is PYQs na now solve madadaga we get to know which are the important areas that we need to focus upon. Second, PYQs inda kelusati there is direct repetition of the questions. 2022 alli certain question bandirutte, 2023 alli kuda there is good chance that questions could get replicated. It has happened. Third, when we solve PYQs, we understand the language that the UPSC uses. Usually we give so many test series of the UPSC coaching institutes. Our way of designing language is slightly different from the UPSC language. And we know in every statement, even a small difference in the word language that is being used could lead to different interpretation by us. So differently interpret madadaga options na correct iradna wrong tagombodu, wrong iradna correct tagombodu. This is one issue which aspirants face. So UPSC language na used to adre, it will actually help when we are solving in the actual exam. Fourth, there is this thing which is being seen that 2021, for example, a given question only 4 options ide. One of the option will be correct. The rest 3 options in that 2022, only it will pick, UPSC will pick one of the options from the year 2021 question and it will frame a direct question in the year 2022. So UPSC PYQs na solve madbekadre bari correct option ಮೇಲೆ focus ಮಾಡೋದು ಅಷ್ಟೇ ಅಲ್ಲ, the other remaining options, what are they, what does it mean, ಅದ್ರ ಮೇಲೆ ಇನ್ ಏನ್ questions na frame ಮಾಡಬಹುದು ಅಂತ ಕೂಡ ನಾವು we will have to understand. So as we proceed on with this video, ಈ question ಅಲ್ಲಿ how are we going to solve this paper? So in this video, first we look at the questions, we'll read the statement each one by one as if we are solving it in the live condition. Second, every question there is certain static syllabus. We'll have a brief outlook in short about the static syllabus that is associated. Third, we'll look what are the common traps. For example, in polity paper common traps sentences UPSC LL kodtare. We'll try to remember it and highlight it. And we'll see if there is any guesswork that could have been made by understanding the UPSC traps. So as we proceed on, we'll be doing this one by one. So let us start with the video. First question, the President of India can summon a session of the Parliament at such place as he or she thinks fit. Second statement, Constitution of India provides for 3 sessions. Constitution of India provides for 3 sessions of the Parliament in a year, but it is not mandatory to conduct all 3 sessions. Okay, there is no minimum number of days that the Parliament is required to meet in a year. First, basic static knowledge, what do we know? It is the President who will summon. Yes, President of India can summon a session of the Parliament at such a place as he thinks fit. This is our correct statement which has been picked from the static syllabus. Inondu, Constitution of India provides for 3 sessions. We know that there are 3 sessions. Which are those sessions? Budget session, monsoon session and winter session. But we know that there are 3 sessions in the Parliament, but is it being mentioned or provided by the Constitution? It is not provided by the Constitution. It is a parliamentary convention that we practice this. Parliamentary convention andre we do it because of the practice. It does not have a legal backing in law or it does not have a mention in the Constitution. Third, there is no minimum number of days that a Parliament is required to meet in a year. This is also correct because Parliament is not been restricted or guided by the Constitution of or any law that you need to meet for a certain number of days. This is one of the biggest criticism that we can write for ineffective functioning of the Parliament, that there is no minimum number of days that the Parliament is required to meet. So Parliament ಮುಂಚೆ ಏನಾಗ್ತಿತ್ತು, in the year 1951 first Lok Sabha, first government form ಆದಾಗ every year they used to meet over a large number of days. But in the recent years, the average number of days that the Parliament is sitting happens itself has reduced. It has come very close to 50 and 60 days in a particular year. So this is one of the drawbacks. So what is the static things which we can learn? President can summon a session, and this power of the president is given by the constitution itself under article 85 clause 1. So president summon ಮಾಡಬಹುದು ಅಂತ ಅಷ್ಟೇ ಗೊತ್ತಿರೋದಲ್ಲ. We need to know whether that power has been given by the constitution or by law, or do we do it because of the parliamentary convention. So president power, it comes under 85(1). Now summoning ಗೊತ್ತು, ಅದೇ ರೀತಿ adjournment Sunday, prorogation, we need to be aware of this. ಯಾರು ಮಾಡ್ತಾರೆ? ಸ್ಪೀಕರ್ ಯಾರು ಮಾಡ್ತಾರೆ? adjournment ಮಾಡ್ತಾರೆ, adjournment Sunday ಮಾಡ್ತಾರೆ. prorogation ಯಾರು ಮಾಡ್ತಾರೆ? president ಮಾಡ್ತಾರೆ. We need to know this, and this is one of the important traps which UPSC gives. The Constitution of India traps ಯಾವ್ದು ಬಂದ್ರು I'll try to highlight in purple ink. Constitution of India ಅಂತ ಕೊಟ್ಟು ತುಂಬಾ ಸತಿ ಅದ್ರ ಮುಂದ್ಗಡೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಫಾರ್ಮುಲೇಟ್ ಮಾಡ್ತಾರೆ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಏನಿದೆ, ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಏನಿಲ್ಲ, we need to make a very good note of it. Is the grounds for the impeachment of the president given in the constitution, or is it only the term that has been mentioned? Is the ground for the removal of High Court and Supreme Court judges mentioned in the constitution? So all these things we need to know. Is the procedure for the removal of High Court and Supreme Court judges mentioned in the constitution? No, it is mentioned in Judges Inquiry Act. So ಯಾತ್ constitutional ಇದೆ, ಯಾತ್ constitutional ಇಲ್ಲ, we need to be aware, because UPSC recurrently has picked this theme and it has asked so many questions over the years. So constitutionally about the 3 sessions mention ಆಗಿಲ್ಲ, it is a parliamentary convention. ಅದೇ ರೀತಿ this is a recurrent theme. So Constitution of India ಅಂತ ಬಂದಾಗ ತುಂಬಾ ಸತಿ what has UPSC done, it has given the wrong statement, because most of the things has been briefly mentioned in the constitution, it is not mentioned in detail. So most of the time Constitution of India provides for this or mentions explicitly and ಕೊಟ್ಟಾಗ statements wrong ಆಗಿದೆ, but every time that may not happen. So we need to be aware of the little bit of things which are there in the constitution, right? Also this thing that there is no minimum number of days that the parliament is required to meet. So this also we need to know. Other thing that we need to know, we know that there will be a sitting in the monsoon session and there will be sitting in the budget session. So between any 2 sessions of the parliament more than 6 months ಇರಬಾರ್ದು, means the gap between the 2 sessions has to be less than 6 months. In simple words, if we tell, it is mandatory for the parliament to have at least 2 sessions in a year, because a year will have 12 months, so 6 months kin ಜಾಸ್ತಿ ಗ್ಯಾಪ್ ಆಗಂಗಿಲ್ಲ. So yearly at least 2 sessions ಆಗಲೇಬೇಕು of the parliament, and whenever the sessions is been held, we do not count when the parliament is been adjourned for more than 4 days, right? So we'll move ahead. This is what I wanted to tell. Article 85 will give the power for the president to summon each house of the parliament, and the constitution does not provide for the 3 sessions to happen. In every year there is no minimum number of days that the parliament is required to meet. Same thing which I told. We look into question number 2. According to the Constitution of India, ನಾನು ಹೇಳಿದ್ನಲ್ಲ ಮತ್ತೆ according to the Constitution of India, this theme will keep on repeating as we go on. According to the Constitution of India, person who is eligible to vote can be made a minister in a state for 6 months even if he or she is not a member of the legislature. Okay. According to RPA Act 1951, a person convicted of criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after the release from the prison. So important themes illi RPA Act 1951. It is a very important act. Mains kuda it has a very good weightage. So we look at the statements. According to Constitution of India, person who is eligible to be vote. Who is the person who is eligible to vote? Anyone who has attained 18 years of age can be made a minister of a state for 6 months even if he or she is not a member of the legislature of the state. We know that a person can be made a MLA or MP even if he is not a member. A person can be made as a minister for a maximum duration of 6 months even if he is not MP or MLA, but within the only maximum duration of 6 months. So within 6 months a person, he will have to contest an election and win if he has to retain the seat of the minister. So someone who wants to become a MLA or MP, what is the age that one requires? 25 years of age. So voting age namige 18 years, ಆದರೆ MLA MP ಆಗಬೇಕಂದ್ರೆ ನಮಗೆ 25 years. MLA MP ಆಗದೆ ಕೂಡ we can become a minister only for a duration of 6 months. So within this duration of 6 months, we'll have to contest the election and win it. Only then we'll retain a seat as a minister. But look at this, according to the Constitution of India, ನಾನು ಹೇಳಿದ್ನಲ್ಲ according to Constitution ಅಂತ ಬಂದ್ರೆ most of the times UPSC has picked up wrong statements. ಇದು ರಾಂಗು, ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ 18 years, ಇಲ್ಲಿ 25 years. So 18 years ಇದ್ರೆ ಸಾಕಾಗಲ್ಲ to become a member of legislature of the state. So this becomes wrong. According to RP Act, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified. ಇನ್ನೊಂದು ಟ್ರ್ಯಾಪ್ ಇಲ್ಲಿ ಏನಂದ್ರೆ, one is this Constitution of India, like we spoke in last statement. ಇನ್ನೊಂದು ಟ್ರ್ಯಾಪ್ ಏನಂದ್ರೆ permanently disqualified. Usually the law or the mechanisms that we have is ತುಂಬಾ long duration imprisonment ಅಥವಾ long duration disqualification ಇದೆ, but most of the cases it is not permanent. ಇಲ್ಲಿ ಅದನ್ನೇ ಪಿಕ್ ಮಾಡಿದ್ದಾರೆ and they have made the statement as wrong. What is the content for it? Actually it is up to 6 years from release. 6 years from release. See, it has been explicitly mentioned in RP Act that someone who has been imprisoned for more than 2 years, then in that case the person shall be disqualified for a period of 6 years from the date of release of the person. ಇದನ್ನೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೂಡ ಲಿಲಿ ಥಾಮಸ್ ಕೇಸ್ ಥ್ರೂ ಹೇಳಿತ್ತು, ಅದೇ RP Act 1951 ಕೂಡ ಮೆನ್ಷನ್ ಆಗಿದೆ, ರೈಟ್? Actually this should have been much better. We shouldn't have allowed someone who has been imprisoned for 2 years to even contest the election. This is one of the reasons why the criminalization of politics is still continuing, right? So we'll move ahead. See, every citizen 18 years, same thing, he needs 25 years to become this, and he shall be disqualified for a period of 6 years. We'll move to question number 3. Which one of the following categories of fundamental rights incorporates protection against untouchability? Fundamental rights, important topic, we know it. So protection against untouchability, ಇಲ್ಲಿ direct literal meaning ಇಂದ ಹೋಗಿ confuse ಆಗಬೇಡಿ. Take the broader thing. See, right to equality is not just Article 14. Article 14, 15, 16, 17, 18, 14 right to equality directly mention ಆಗಿದೆ. Right to protect against discrimination, it is also providing for equality. To provide right to opportunity for every person, even if he does not have a equal standing with others, that is also right to equality. Right against untouchability, which will provide the disprivileged people equal rights in par with others, that is also right to equality. The answer to this is right to equality. Right to constitutional remedies ಬರೋದು ಆರ್ಟಿಕಲ್ 32 ಅಲ್ಲಿ. ರೈಟ್ ಟು ಫ್ರೀಡಮ್ is article 19 to 22. Right against exploitation is article 23 and 24. So in the first instance ನಾವು ನೋಡಿದಾಗ protection against untouchability ಅಂತ ಇದ್ದಾಗ we might look for article 17 in the option, but when we see right against exploitation, right to freedom ಅಂತ ನೋಡಿದಾಗ ಗೊತ್ತಾಗತ್ತೆ, ಓ they are broadly speaking of the categories. article 19 to 22 ಈ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ ಬರುತ್ತೆ. ಸೊ ಆ ಸೆನ್ಸ್ ಅಲ್ಲಿ this is right to equality. So also we'll have to know few other things with respect to fundamental rights. Are fundamental rights sacrosanct? Are they permanent? No. They can be amended. But can all the fundamental rights be amended? No. Those things which are mentioned in the basic structure cannot be amended, as said in Keshavananda Bharati case. Which are the fundamental rights which are available only to the citizens of India? There are 5 fundamental rights which are available. Article 15, 16, 19, 29, 30. Rest of the fundamental rights are available even to foreigners and not just the citizens. So from where have we picked the Fundamental rights, it is from US Constitution. Ivella basics we will have to know. We will move on. Same thing, right to equality 14-18, right to freedom 19 to 22, and right against exploitation 23-24. Okay, we'll move to question number 4. Which part of the Constitution declares the idea of welfare state? Option A, DPSP, option B, fundamental rights, option C, preamble, and option D, 7th schedule. Which part declares the ideal of welfare state? See, 7th schedule is the division of power between the center and the state. That is what makes India a federal structure. So, idu division of power jate deal madute, this is not the answer. Ideal of welfare state is also not, this is also not the option, because fundamental rights, now these are guidelines to the, now these are rights of the citizens against the state. Citizens have certain degree of rights which the state cannot take in general case. So, citizens have the right, have fundamental rights against the state or even legal entities such as companies or even against certain other individuals. So, this is not the idea of welfare state. Idea of welfare state, now this remaining options DPSP ಮತ್ತೆ preamble ಇದೆ, ಇಲ್ಲಿ confuse ಆಗಕ್ಕೆ ಹೋಗಬೇಡಿ. Idea of welfare state, the answer to this is DPSP. DPSP provides moral guidelines to the state to ensure the welfare prospects. So DPSP ಇಲ್ಲಿ ಎಷ್ಟೊಂದು provisions ಇದೆ. For instance, article number 46 SC/ST development ಮಾಡಬೇಕು. Article 45 for healthy development of children. Article 42 maternal health. So on, there are articles which ensures that the state fulfills the welfare role. Preamble just mentions about the introduction. It is an introduction to the upcoming provisions in the Constitution. It is an intro to the provisions of the Constitution which will come ahead. So preamble does not give the idea of welfare state. Yes, preamble speaks about equality, it speaks about liberty, but it is just an introduction or the summary of what will appear in the Constitution later. It is DPSP which provides proper provisions of the welfare state. Now this question has been picked from the PYQ and it has appeared in PYQ twice. So il confusion anta agangidre, it should only have been DPSP and preamble. The answer is DPSP. Adan bit bere yadru madhyanu confusion aglebaradu, right? One common agreement between Gandhism and Marxism. If you look at this question, this was a bouncer because we know about the Gandhian principle, but Marxism is a sociological topic. Those who have sociological optional would have been aware of this, but general agi think madad kashta. Karl Marx ಬಗ್ಗೆ ಎಲ್ಲರೂ ಕೇಳಿರ್ತಾರೆ, but in depth what are his principles, what is his theory, ತುಂಬಾ ಜನಕ್ಕೆ ಗೊತ್ತಿರಲ್ಲ. So what are the options that are available? The final goal of stateless society, class struggle, abolition of private property, economic determinism. Now Marxism ಬಗ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಲ್ವಾ, so we look at Gandhism and how we could have deduced. Did Gandhi speak of class struggle? Class struggle would include violence, and Gandhi was one person who has always upheld the principle of non-violence. So idantu alla. Abolition of private property. Gandhi did not speak about abolition of private property. He spoke that everyone should have limited resources so that it is scattered among everyone. He just wanted to prevent the inequality that was present, not the abolition of private property. Economic determinism, in the sense economic factors would govern all other things. Economic factors governs everything else. Governs everything. Did Gandhi speak of such a principle? No, he didn't. So option A is the answer. The final goal of stateless society. What did Gandhi speak of stateless society? Gandhi wanted village republics or village autonomy. Gandhiji wanted village autonomy. He wanted villages to act as republics which were independent. He was against the parliamentary system that was been functioning. He did not want a centralization of function. He wanted people to live in the rural setup, to be ecologically sustainable, and he wanted them to function as independent units and self-sufficient units rather than being under the central unit such as that been followed in the parliamentary system. And what did Marxism say? Marxism also wanted the final goal of a stateless society, because Marxism, if we have to look at the theory of Marxism, we'll briefly look at it. Marxism theory ಏನನ್ನತ್ತೆ? See, Marxism, Karl Marx theory, he gave most importance to economic factors. He said that economic factors governs everything. Family, household, occupation, type of society, all of that is decided by the economic factors. This is what he said. So he said when there is economic factors, there will be inequality that will be existing. So he gave two classification, that there will be haves and haves not. Haves not ಅಂತ ಡಿವಿಷನ್ ಆಗುತ್ತೆ ಸೊಸೈಟಿಲಿ. ಹ್ಯಾವ್ಸ್ ಅಂದ್ರೆ ಎಲ್ಲಾನು ಇರುತ್ತೆ, ಇವ್ರ ಹತ್ರ ರಿಸೋರ್ಸಸ್ ಇರುತ್ತೆ, ಮನಿ ಇರುತ್ತೆ. ಹ್ಯಾವ್ಸ್ ನಾಟ್ ಹತ್ರ ಇರಲ್ಲ. ಸೊ ಇವ್ರ ಹತ್ರ ಇರುತ್ತೆ, ಇವ್ರ ಹತ್ರ ಇರಲ್ಲ. ಸೊ ಹ್ಯಾವ್ಸ್ ನಾಟ್ ಏನಾಗುತ್ತೆ, ಆಫ್ಟರ್ ಅ ಡ್ಯೂರೇಷನ್ ಆಫ್ ಟೈಮ್ will do class struggle. They will do class struggle on the haves, because they will have scarcity of resources and these will have the resources. So they will do class struggle, take the ownership of the property, and once they take the ownership of the property, he made an assumption that these have not will scatter, or they will divide those resources among all the people, and in such a way that it will lead to abolition of private property. Private property anna concept ಹೋಗ್ಬಿಡುತ್ತೆ, because now everyone, they are free to do whatever they want, and there will be no concept of private property. This is what Marx has said in his theory through proletariat revolution. Haves na bourgeois antare, haves not ke proletariat antare Marx. And when this will happen, he said that there will be stateless society, there will be no government, people would be free to do whatever they want. Each of them would ensure that they do their creative thing which they wanted to do throughout their life, instead of just working for the sake of money or resources. It did not happen, so it has just been a utopia till now. Marx Gandhism ಬಗ್ಗೆ ಕೇಳಕ್ಕೆ, I just wanted to discuss about this in brief. So same thing which I spoke about, he spoke about the end result would be stateless society. So we look into question number 6 with reference to the provisions contained in part 4. Part 4 means DPSP. Which of the following statements are correct? They shall be enforceable by courts. You know that DPSP, they are non-enforceable. They shall not be enforceable. This is correct. See, ಕೆಲವು ಸತಿ UPSC ಏನು ಮಾಡುತ್ತೆ, ಕಾಂಟ್ರಡಿಕ್ಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡುತ್ತೆ. 1 is opposing 2, 2 is opposing 1. So 1 and 2 options ಅಲ್ಲಿ ಇರೋದು ಪಕ್ಕಾ wrong, but they have not formed such options. But usually we see that these things also happen. So they shall be enforceable by courts, they shall not be enforceable by court. No, this is correct. The principles laid down in this part are to influence the making of laws by the state. This is also correct. Basic question. Ee tara questions we cannot afford to make mistake. This is what we discussed earlier also. So these are the provisions. So DPSP ಎಲ್ಲಿಂದ pick ಮಾಡಿದ್ವಿ, and all the provisions of DPSP, article 51, 50, 49, 48 ಈ ತರ ರಿವರ್ಸ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಎಲ್ಲ ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. From article 36 to article 51, article 36 to 51 DPSP ಆಯಾ provisions ಇದೆ, ಎಲ್ಲಾನು ನಮಗೆ ಗೊತ್ತಿರಬೇಕು, so that we can even use it in the mains answers. Also few other things which I wanted to talk about DPSPs. See, DPSP, they act as the directive principles. They are the moral guidelines which the state is need to follow. Our forefathers said that any government that is in power, they cannot neglect to fulfill DPSPs, because if they neglect, then the people would not elect them. This is what our forefathers had in mind when they brought DPSPs. So that is why they did not make it justiciable, because even if they are non-justiciable, they believe that the governments need to follow, so that they are in power, they continue to be in power. So these principles are both for central government or state government or any government that has been there, and they cannot be enforced in any court of law. This is also correct. So what do they bring in? See, these are constitutional instructions to the state to ensure the welfare of its citizens. So it makes the character of Indian state a welfare state, justice, liberty, equality, fraternity, through these principles. And they are aimed at socio-economic democracy. See, what does fundamental rights aim for? Fundamental rights aim for the political democracy, equal voting rights, universal franchise, right to equality, all this. So it is ensuring political democracy, whereas DPSPs are ensuring social and economic democracy, equal pay for men and women. These provisions are there in the DPSP, ensuring socio-economic democracy. Promoting good governance. See, these are like main sort of points. Yes, it promotes good governance. Good governance ಅಂದ್ರೆ ಏನು? ರೆಸ್ಪಾನ್ಸಿವ್ನೆಸ್ ಇರಬೇಕು, ಎಂಪತಿ ಇರಬೇಕು, ಎಫೆಕ್ಟಿವ್ನೆಸ್ ಇರಬೇಕು, ರೂಲ್ ಆಫ್ ಲಾನ ಎನ್ಶೋರ್ ಮಾಡಬೇಕು, ಪಾರ್ಟಿಸಿಪೇಟರಿ ಇರಬೇಕು, ಅಕೌಂಟಬಿಲಿಟಿ ಇರಬೇಕು, right? Consensus with law irbeku, transparency irbeku. So DPSP does ensure good governance, and it also aids the judiciary. Judiciary has said that any law which gives effect to DPSP shall be considered as valid under Article 14, Article 19. So even Supreme Court has said this many times, because we need a law to enforce DPSPs. Without the law directly, it cannot be made enforceable, though they act only as the principles for the state. We'll look into question number 7. Preamble of the Constitution of India. It is a part of Constitution but has no legal effect. It is not a part of Constitution and has no legal effect either. Part of Constitution and has same legal effect as any other part. It is a part of Constitution that has no legal effect independently. Now many of us, while solving this question in the actual exam, did not very clearly understand of this word no legal effect independently. Now we look at this. So preamble is a part of Constitution. It is telling preamble is not a part of Constitution. So this becomes wrong. Preamble is a part of Constitution and has the same legal effect as any other part. We know that just like DPSP's preamble is non-justiciable. So it has same legal effect as any other part. For example, Constitution has fundamental rights. Now this is justiciable, whereas preamble is non-justiciable. So it is not as same, it does not have the same legal effect as any other part. So idu wrong aitu. Next, a part of the Constitution that has no legal effect. This is correct. Directly adanna enforce madakagala. But look at this, a part of the Constitution that has no legal effect independently. It is telling that preamble could have legal effect, but independently does not have the legal effect. In the sense, if we want to fulfill or make the provisions of the preamble justiciable, then we need law. Independently, preamble without the law cannot be made justiciable. This is a more comprehensive capture of the picture of preamble. So this is the answer. Part of the Constitution but has no legal effect. This becomes wrong because it can have legal effect if a law is been made to fulfill the provisions of preamble. Preamble liberty antide. Liberty goskara, for example, right to privacy, Digital Personal Data Protection Act, that is protecting the liberty. So that is giving effect to the provisions of preamble of liberty. So adhe tara enen terms preamble ilide, adike if we make some law, then it will have legal effect. But generally it does not have legal effect if there is no law. So adike independently it does not have legal effect, but if you make law, it does have legal effect. Right? So this was a confusing question in the exam. See, same thing, preamble. And preamble ಬಗ್ಗೆ ಬೇರೆ ಇನ್ನೇನಾದ್ರು ಗೊತ್ತಿರಬೇಕಂದ್ರೆ these are the things. See, preamble, there were 3 cases. One is Berubari Union, one is Keshavananda Bharati, and one is LIC. So in the Berubari Union, Supreme Court said that preamble is not a part of the Constitution and a law cannot be made to give effect to the preamble. Keshavananda Bharati case alli Supreme Court overruled its judgment. It said that preamble is a part of the Constitution and laws can be made to give effect to the preamble. So Supreme Court changed its decision. It reversed its decision. So that is what Supreme Court has the power to review its own judgment. Idr mele kuda statement bandide. It has that power under Article 32. Likewise, in the LIC case, Supreme Court reiterated the fact that preamble is an integral part of the Constitution. So Berubari Union, Keshavananda Bharati and LIC case are related to preamble. We'll move ahead. Question number 9, consider the following statements. The Constitution of India defines its basic structure. Like I said, the same thing. Constitution of India, this thing again has appeared, defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. It does not define. Basic structure has not been defined. Look at the second statement. The Constitution of India provides for judicial review to safeguard the citizens' liberty and to preserve the ideals on which Constitution is based. Now one thing which I want to highlight here is, see, Constitution of India defines its basic structure. We know that it is wrong. Basic structure is what is been said by the Supreme Court. It does not have a backing in the Constitution, right? But look at this, Constitution of India provides for judicial review. We know that it is the power of judicial review through which Supreme Court or the High Court will keep a check on the executive action or the legislative action that is being taken. ಆದರೆ ಅದೇ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ಲಿ ಪ್ರಾವಿಷನ್ಸ್ ಇದೆಯಾ? ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ, it is implicitly provided under Article 13, because Article 13 says any law which is in contradiction to fundamental rights shall be declared as void, providing for judicial review. But ಏನಾಗುತ್ತೆ ಕೆಲವು ಸತಿ UPSC itself will take out controversial key, and this was one of the controversial key. When we studied in the test series and books, we studied that judicial review is being provided by the constitution. Provided andre we took it implicitly, but UPSC key when it gave the answer, it took this to be wrong. It said the answer is D. Every institute said answer is B because we took the implicit meaning, but UPSC it took that constitution has not explicitly mentioned or provided for judicial review, and that is why it took this statement to be wrong. ಈಗ ನಾವು UPSC ಏನು ಮಾಡಿದರೆ subsequent years same question ಮಾಡಿದ್ರೆ we'll have to take UPSC answer key to be correct, though it is controversial at times. So answer for this is D. Likewise the same thing, Constitution of India does not define, and basic structure idea ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಕೇಶವಾನಂದ ಭಾರತಿ ಕೇಸಲ್ಲಿ basic structure ಕೊಟ್ಟಿರೋದು. So basic structure ಬಗ್ಗೆ Supreme Court has not given very comprehensive code. Case to case basis ali it has set so many provisions like federalism, independence of judiciary, secularism, democratic structure, all these things it has said in so many cases, but there is no proper codification of basic structure that is yet to be done. So broad idea irbeku basic structure alli enen barutte anta. So basic structure alli baro tenets namage gottidre we can easily attempt questions if a question has been asked on it. See, like I said, there is no explicit provision in the Indian Constitution with regard to judicial review. So that is why UPSC has taken this to be wrong, but implicitly most of the institutes had taken it implicitly and they said the answer was correct, but UPSC key was wrong. We'll move ahead. Question number 10. A parliamentary system of government is one in which all political parties in the parliament are represented in the government. All political parties, see we are talking about the Indian government. See parliamentary system India dalli ide. So Indian government na mind alli itkonಡ್ರು ಕೂಡ ಇದನ್ನ ಸಾಲ್ವ್ ಮಾಡಬಹುದು. All political parties in the parliament are represented in the government. No, there is only one party or coalition that happens in India. This becomes wrong. Government is responsible to the parliament and can be removed by it. This is correct. Government is elected by the people and can be removed by it. No, this becomes direct democracy. In India we follow indirect democracy. Direct democracy is seen in countries such as Switzerland. Now this is direct democracy. Right to recall antivi idina. If people want, they can directly remove the government officials. This is not present in India. The government is chosen by the parliament and cannot be removed by it before completion of fixed term. This is also wrong. Government of the day can be made to fall or removed through no confidence motion. No confidence motion. So this is a easy question. Government is responsible for the parliament and it can be removed by it. ಇದನ್ನೇ ಬೇರೆ ಬೇರೆ ರೀತಿಯಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಗವರ್ಮೆಂಟ್ ಅಂದ್ರೆ ಏನು, ಪಾರ್ಲಿಮೆಂಟರಿ ಗವರ್ಮೆಂಟ್ ಅಂದ್ರೆ ಏನು, ಈ ತರ ತುಂಬಾ ಸತಿ ಕೇಳಿದ್ದಾರೆ. in case parliamentary system of government ಮೇಲೆ ಕ್ವಶನ್ ಬಂದ್ರೆ ಕನ್ಫ್ಯೂಷನ್ ಆದ್ರೆ think with presidential system. Presidential form of government, parliamentary form of government, ಇದ್ರ ಮಧ್ಯೆ ಡಿಫರೆನ್ಸ್ ಜ್ಞಾಪಕ ಮಾಡ್ಕೊಂಡ್ರು ಕೂಡ ಈಸಿಲಿ ಪಾರ್ಲಿಮೆಂಟರಿ ಸಿಸ್ಟಮ್ ಏನು ಡಿಫರೆನ್ಶಿಯೇಟಿಂಗ್ ಫ್ಯಾಕ್ಟರ್ಸ್ ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೊಬಹುದು. We'll move ahead. See which I wanted to say. I'll highlight the features of parliamentary system. See nominal real executive, nominal ಅಂದ್ರೆ ಪ್ರೆಸಿಡೆಂಟ್ ಇರ್ತಾರೆ, real executive ಅಂದ್ರೆ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಇರ್ತಾರೆ. There is close connection between the legislative and the executive power. Yes, because the member of the executive such as ministers, they are also the member of legislative. Collective responsibility irutte, which means that all the ministers, they are collectively responsible. If a minister, if he disagrees with the prime minister, then he will have to resign. And if the government falls, then it is not just individual minister, the entire group of ministers, council of ministers or the cabinet, they will have to resign together. There is political homogeneity between the members of the party because usually one party will form the government. There is dual membership, which I said, one is of legislative and one is of executive. Then it is also said prime ministerial government because it is the prime minister who is the supreme person, and it is characterized by the dissolution of Lok Sabha. Only the Lok Sabha can be dissolved, the Rajya Sabha cannot be dissolved. We'll move ahead. This is another interesting question that had been asked in the UPSC. See, in India, legal service authorities provide free legal services for which of the following types of citizens? Person with annual income less than 1 lakh, transgender with annual income less than 2 lakh, member of OBC with annual income and all senior citizens. See, we know about NALSA, National Legal Services Authority. So free legal aid, to promote free legal aid, these provisions and act had been made. So it had given a list of persons who are eligible for free legal aid. So ಯಾರ್ಯಾರು ಬರ್ತಾರಂತ ನಮ್ ಜ್ಞಾಪಕ ಇದ್ರೆ we could have solved this. We look into this. ನಮ್ ಜ್ಞಾಪಕ ಇಲ್ದೇಗಿದ್ರು ಕೂಡ how we could have eliminated this. See, look at option number 4, all senior citizens. There are so many senior citizens who are millionaires or billionaires. For example, all senior citizen would have included the late Ratan Tata also. Do we need free legal services for Ratan Tata? So all senior citizens provision is wrong. ಇದು ನಮ್ಗೆ ಜ್ಞಾಪಕ ಇಲ್ದಾಗಿದ್ರು ಕೂಡ ನಾವು ಹೇಳ್ಬೋದಿತ್ತು, it doesn't make any sense ಅಂತ. So ಇದು eliminate ಆಗ್ತಿತ್ತು. Person with annual income of less than 1 lakh, this is the first provision or the first condition that has been mentioned if you study free legal services ಅಲ್ಲಿ ಯಾರ್ಯಾರು eligible ಅಂತ. So 1 is correct. 1 correct ಆದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಿರ್ತಿತ್ತು ಆನ್ಸರ್. ಟ್ರಾನ್ಸ್ಜೆಂಡರ್ ಬಗ್ಗೆ ಕಾಮನ್ ಕನ್ವೆನ್ಷನಲ್ ಬುಕ್ಸ್ ಅಲ್ಲಿ ಇಟ್ ವಾಸ್ ನಾಟ್ ಬಿನ್ ಮೆನ್ಷನ್ಡ್. ಅದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲದಿದ್ರು ಕೂಡ 4 ನ ಎಲಿಮಿನೇಟ್ ಮಾಡಿದ ಮೇಲೆ 2 ಆಪ್ಷನ್ ಅಲ್ಲಿ 2 ಇತ್ತು. ಸೊ ಮೆಂಬರ್ ಆಫ್ OBCs ವಿತ್ ಆನ್ಯುವಲ್ ಇನ್ಕಮ್ ಆಫ್ ಲೆಸ್ ದೆನ್ 3 lakh, ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ಮೇಡ್ ಅಪ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಬಿನ್ ಪ್ರೊವೈಡೆಡ್, ರೈಟ್? ಸೊ if we knew statement 1 which is present in the static books that we study, but 4th and 3rd and 4th statement they are made up. So 4th now think ಮಾಡಿ, yes, all senior citizens they may not be eligible anta think madidre we would have got this as correct. We'll move ahead. So same thing, Legal Services Authority Act was been done in the year 1987. So it provided for NALSA at the national level. NALSA tarane state level alli SALSA anta barutte, district level alli DALSA DALSA anta barutte. So likewise they have divided the work among themselves. So who are eligible under free legal services? We need to have a broad idea. Nodi tumba jasti understanding bada, mostly the vulnerable section who are not able to take care of themselves. So SC, ST, woman, child, trafficking in human beings, mentally ill, disabled persons, or victims of disaster, ethnic violence, caste atrocity. So industrial workmen who work for very low wages sort of thing. So these are the persons who are eligible. Vulnerable persons are eligible anta ನಮ್ಮ ಮೈಂಡ್ ಅಲ್ಲಿ ಇದ್ರು ಕೂಡ ಆ ಕ್ವಶನ್ we could have cracked. We'll move ahead. Question number 12. Other than fundamental rights, which of the following parts of the Constitution of India reflects the principles and provisions of Universal Declaration of Human Rights? Now we had heard about Universal Declaration of Human Rights, but in general we do not remember or gone through the provisions of Universal Declaration of Human Rights. So ನಮ್ಗೆ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಗೊತ್ತಿಲ್ಲದೆ ಕೂಡ ಹೇಗೆ ನಾವು ಥಿಂಕ್ ಮಾಡ್ಬೋದು. ಸೊ ಯೂನಿವರ್ಸಲ್ ಡಿಕ್ಲರೇಷನ್ ಇನ್ ದ ಸೆನ್ಸ್ ದೇ ವುಡ್ ಹ್ಯಾವ್ ಟೇಕನ್ ಅ ಬ್ರಾಡ್ ಸೆಟ್ ಆಫ್ ವೆರೈಟಿ ಆಫ್ ರೈಟ್ಸ್. ಸೊ ಇಟ್ ವುಡ್ ಹ್ಯಾವ್ ಇನ್ಕ್ಲೂಡೆಡ್ ದ ರೈಟ್ ಟು ಸ್ಪೀಚ್, ದ ರೈಟ್ ಟು ಸೆಲ್ಫ್ ಡೆವಲಪ್ಮೆಂಟ್, right against atrocities, right to press, right against atrocities, right to safe environment. So Universal Declaration of Human Rights means these are basic rights which anyone should have. So there would have been a bundle of rights that would have mentioned under this thing. So adina nam mind alli idkondidre how is that we could have solved. See, Preamble provides for liberty. So idu iro chances ittu. Idu one thing mind ge bandru, liberty, equality, this is what it would have provided for. DPSP li kuda ide about the gender rights, equal pay for both men and women, healthy development of children, to take care of health, to provide for healthy provisions of those working in industries. This sort of provisions ide. Fundamental duties al kuda to not to engage in practices which are derogatory to women. These provisions are there in fundamental duties also. So ee tara think ಮಾಡಿ broad perspective ತಗೊಂಡಿದ್ರೆ then we could have easily answered it as 1 2 3. So ee tara broad questions ಬಂದಾಗ take the most broadest perspective that you can think of. We'll move ahead. See, Universal Declaration of Human Rights, like I said, right to life, right to liberty, right to security of persons, right from torture and cruel treatment, freedom of thought, conscience, freedom of opinion, expression. So broadly, most of the rights which are needed for a person, for a healthy lifestyle, for personal development, that is being included in this. right to free elections and all sort of things. So in such things, even if we do not know the exact thing, we could have answered by taking the broader meaning. Likewise, question number 13, a constitutional government by definition. See, ಇದನ್ನ ಬೇರೆ ಬೇರೆ ರೀತಿ so many years ಅಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ. Constitutional government by definition is a government by legislature. Wrong. A popular government. No. A multi-party government. Not essentially. It is a limited government. Name itself tells it is a constitutional government. Constitutional government in the sense there is a constitution which will limit the government's power to make laws, to exercise power. So the power of the government is been restricted by the constitution. It is needed for any country to function to prevent the over exercise of the power by the government. So constitution, if it is written, if there is an independent judiciary to enforce the written constitution, if the constitution is rigid, all these provisions ensure that the government of the day do not exercise arbitrary power or excessive power. ಇದನ್ನೇ ಬೇರೆ ಬೇರೆ ರೀತಿಯಲ್ಲಿ ಕೇಳಬಹುದು, ಅದರ ಬೇಸಿಕ್ ಐಡಿಯಾ ಇರಬೇಕು. In India, it is the constitution which is the supreme entity, and all other parts they derive their power from the constitution and are restricted by it. We'll look at the question number 14. Along with the budget, the finance minister places other documents before the parliament, which include macroeconomic framework statement. The aforesaid document is presented because this is mandated by which of the following? Long-standing parliamentary convention. Convention we already spoke of, means it has been followed by practice. No. Article 112 and 110. So money bill, mate annual financial statement, which is nothing but the budget. So idrinda ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದರೆ, this is also wrong. Article 113, no, this is also wrong. It is according to the provisions of FRBM Act 2003. This is the right answer. So FRBM Act has mandated that along with the budget, there are 3 documents which needs to be presented. So which are those 3 documents? See, FRBM Act 2003 has provided for, it has asked 3 documents needs to be submitted. One is fiscal policy strategy. Fiscal policy strategy, medium term fiscal policy strategy, and the third one is macroeconomic framework statement. So these 3 has been mandated by FRBM Act. We need to know of this, and that too macroeconomic framework is more important than the others. We'll look why. See, FRBM Act, it has mandated, we got to know it. So what does FRBM Act speak of? See, FRBM Act alli India's fiscal deficit hegide, how will we improve the macroeconomic management, what steps will we take to ensure fiscal discipline. So ivelladra ಬಗ್ಗೆ it speaks of. So three documents which I spoke of: medium term fiscal policy statement, fiscal policy strategy statement, macroeconomic statement. These 3 are the more important. Idra mele innond reeti kuda question could have been framed. Macroeconomic statement is specifically mentioned under section 3 of FRBM Act. Directly a question could have been picked from here, that which of the following document is been specifically mentioned under section 3 of FRBM Act. ಈ ತರ ಕೇಳಿ ಈ 3 ಆಪ್ಷನ್ ನೇ ಆಪ್ಷನ್ ಎ, ಆಪ್ಷನ್ ಬಿ, ಆಪ್ಷನ್ ಸಿ ಅಂತ ಕೊಟ್ಟು ಕನ್ಫ್ಯೂಸ್ ಮಾಡಬಹುದು. ಸೊ ಅವಾಗ ನಾವು ಕನ್ಫ್ಯೂಸ್ ಆಗಬಾರದು. ಸೊ ದಟ್ ಇಸ್ ವೈ ಐ ವಾಂಟೆಡ್ ಟು ಟಾಕ್ ಆಫ್ ದಿಸ್. ವಿಲ್ ಮೂವ್ ಅಹೆಡ್. Question number 15. In India, separation of judiciary from the executive. So this is a very simple question. In India, separation of judiciary from the executive is being enjoined by judiciary and executive separation. Can we recall of anything? Yes, we can recall of Article 50. Preamble alli idya? It is not there. 7th schedule division of power alli idya? It is not there. Conventional practice, just made up thing. DPSP under Article 15, separation of executive and the judiciary. See, in India, there is no absolute separation of power. Absolute separation of power andre executive domain alli legislature involve agalla, legislature domain alli judiciary involve agalla. What we follow is relative division of power. That means there is separation of power to an extent that one does not hinder the functioning of the other. But if one tries to over exercise the power, then the other may intervene to ensure rule of law or the constitutionalism. What I meant is separation of power mainly It is the three organs which have the power: legislative, executive and the judiciary. We want independent functioning of each of these organs, but we do not want any one of the organ to have absolute power. So judicial review it will keep a check on the legislative laws that have been made or the executive actions that have been taken. Impeachment motion of judges either through judiciary ali judges properly function madegidre, then the legislature can remove them. So likewise, each one of them ensures checks and balances over the other. And why do we do this? We do this to prevent misuse of power. And this idea of separation of powers is not new to us. It has been said by 17th, 18th century philosopher itself, Montesquieu. In sociology or PSIR, we study this in detail, that he spoke about the doctrine of separation of power. And that is what even India follows to date. Question number 16, Rajya Sabha has equal powers with Lok Sabha. See, this is also direct static question. Where does it have equal powers? Matter of creating all India services? No, this is a privilege of Rajya Sabha. Amending constitution? Okay. Removal of the government? This is a exclusive power of Lok Sabha. Likewise, making cut motions, this is a power of Lok Sabha, exclusive power of Lok Sabha, which the Rajya Sabha does not have. So Rajya Sabha has certain special privileges or powers compared to the Lok Sabha. We should be aware of it. If you want Parliament to make a law on the state list, then Rajya Sabha has to pass a motion. If you want to create a new all India services, then Rajya Sabha has to initiate the motion. Likewise, if during the time of emergency any law is been made, then that law will be effective only if Rajya Sabha approves it. So even when the Lok Sabha is been suspended due to government not been formed, then in that case also, if any ordinance is been made by the president, then that will need the approval of Rajya Sabha to be intact, because Lok Sabha will have to approve it only when it's formed again. So Rajya Sabha has certain special privileges, and also Lok Sabha has certain privileges. See, Article 49, Parliament to make a law on the subject which is in the state list. So idu Rajya Sabha special privilege. All India services create madbeka, then Rajya Sabha. One more thing which I wanted to tell, if there is a resolution to remove vice president, then such a resolution has to be initiated by the Rajya Sabha only. Vice president na remove madbekane Lok Sabha cannot initiate it. Rajya Sabha will have to initiate it, Lok Sabha will have to agree it by majority. See, resolution for the removal of vice president, that can only be introduced in Rajya Sabha. This is also special power. And same thing which I said, emergency proclamation, if it is been made, then it will remain effective only if approved by Rajya Sabha. Likewise, Lok Sabha will have certain powers. The Speaker of Lok Sabha will preside in the joint sitting. Cut motions, money bill, all these things, they are the privilege of the Lok Sabha. You can remove the government of the day, and that can only be done by Lok Sabha, because the government is responsible only for the Lok Sabha and not for the Rajya Sabha. So ivella basic things ಬಗ್ಗೆ ಗೊತ್ತಿರಬೇಕು, and these are pocket marks. We cannot make mistakes in this, right? We look at other question. In the context of India, which one of the following is characteristic appropriate for bureaucracy? Simple thing they have been asked, and they're just trying to understand what is that you understand by the statements. Are you able to take the broad meaning or not? An agency for widening the scope of parliamentary democracy. See, it is an agency to fulfill the objectives of parliamentary democracy, to bring democratic principles, but not to enhance, widening the scope. An agency for strengthening the structure of federalism. Okay, look at other statement. An agency for facilitating political stability and economic growth. Okay, look at D statement. An agency for the implementation of public policy. A one statement which can easily be used to define bureaucracy is that bureaucracy is meant for the implementation of public policy. So the answer to this question is D. But do not get confused. See, even these, if you are writing a mains answers, maybe we could have written these points, that the agency, bureaucracy as an agency can strengthen federalism. How? IAS officer will be serving under state government, then they go to central deputation. So they are acting as a bridge between state and central government, also between the leaders, if they have to make certain decision on consensus. So ivalla mains answer okay. Other one statement which defines bureaucracy very clearly is this. See, agency for economic growth. Yes, we need economic growth, because if you frame or formulate good laws with the help of bureaucrats, then it can bring in economic growth. And if there's economic growth, if there's business, if there's employment, it will also ensure political stability, right? So these are statements which you could have written for mains, but in this case it was D which was the answer. The same thing has been mentioned. And bureaucracy also, when we speak of, we need to be aware of Weberian bureaucracy things also. Though it has not been mentioned in polity, it could be asked. Just like Marxism na ಕೇಳಿದ್ರಲ್ಲ ಅದೇ ರೀತಿ Weberian bureaucracy ಇಂದ ಕೂಡ questions ಬರ್ಬೋದು. So please have a look at it. Look at the next statement. Consider the following statements. Aadhaar metadata cannot be stored for more than 3 months. Okay. State cannot enter into a contract with private corporations for sharing Aadhaar data. State cannot enter with private corporations. Aadhaar is mandatory for obtaining insurance products. Okay. Aadhaar is mandatory for getting benefits out of Consolidated Fund of India. So all these provisions and this question has been picked from Aadhaar Act of 2016. See, traps LL kodate UPSC. So we'll look at this, then we'll look at traps. See, Aadhaar metadata cannot be stored for more than 6 months. It is not 3 months. So this becomes wrong. State cannot enter into contract with private corporations for sharing Aadhaar data. This is correct because we want to promote the right to privacy of the individual. Aadhaar will have so much of data and the private corporations could misuse it for their profits. So government cannot directly enter into private corporations for sharing of this data. This is correct. Aadhaar is not mandatory for obtaining insurance products. Aadhaar is mandatory for getting benefits out of Consolidated Fund of India. Idu hege aito, see, Aadhaar Act 2016, it had been passed as a money bill. It was one of the controversial things because Aadhaar Act na normal bill anta pass mada badlu, they passed it as a money bill. So what happened? Rajya Sabha, which is usually a revisory body, did not get a check on it. Because money bill, it will only be discussed and decided by the Lok Sabha. So Rajya Sabha out aito, Aadhaar Act bantu. So Aadhaar Act alli kuda Supreme Court used the doctrine of severability. See, doctrine of severability ಏನಾಗುತ್ತೆ? For example, it had been applied on Aadhaar Act. There were certain provisions in the Aadhaar Act which it considered as constitutional and certain provisions which went against the constitution. So the provisions which went against, Supreme Court, it removed those provisions and kept only those provisions which were in sync with the constitution to be valid. So doctrine of severability na doctrine of separation kuda antare. So Supreme Court, it will take up a law, certain provisions which are against, it will remove and it will keep up the remaining provisions. So Aadhaar Act alli, what is that Supreme Court has said? If the money is moving from Consolidated Fund of India for the purpose of subsidies or benefit to the people, then Aadhaar becomes mandatory. But if the citizen is paying money for any of the benefits that is taking, for example, if it is an insurance product, if it is pension, then the citizen is paying money. So in such cases, Aadhaar is not mandatory. If he is taking admission into UGC or any other colleges, then the college cannot mandatorily ask for Aadhaar. So this is what Supreme Court has said. But if you are taking any benefits, if you are taking direct benefit transfer, if you are taking subsidy, then Aadhaar becomes mandatory because the money is coming from the exchequer or the Consolidated Fund of India. So our case is mandatory agutte. This is what Supreme Court had said. And Aadhaar data cannot be stored for more than 6 months. Supreme Court timeline kuda kottittu provisions through. Initially, state wanted to enter into contract with private corporations, but Supreme Court reversed this decision and said it cannot share data with the private corporations. So same thing has been mentioned here. Supreme Court ruled Aadhaar metadata cannot be stored for more than 6 months. Same thing. And this Aadhaar Act 2016 al bandira, adre 2018 al judgment bandira. It is mandatory. It is not mandatory if it's not welfare scheme. Right? State government, all these things for subsidies, benefits of services, only for that case it will become mandatory. And Aadhaar is not used to make India into a surveillance state. So there is balance for the use of Aadhaar because Supreme Court through these provisions has ensured that state does not turn into a surveillance state because of Aadhaar. So court had also upheld the decision of Lok Sabha Speaker as he took Aadhaar Act to to be a money bill. Supreme Court ಈ decision upheld ಮಾಡಿದೆ, though it was controversial. Likewise, we look at into the next question with reference to funds under MPLADS. See, MPLADS topic ಅನ್ನೋದು ಮುಂಚೆ ತುಂಬಾ ನ್ಯೂಸ್ ಅಲ್ಲಿ ಇತ್ತು, ಈಗ ಈ ನಡುವೆ ಅದ್ರ ಮೇಲೆ ಕ್ವಶನ್ಸ್ ಅಥವಾ ರೀಸೆಂಟ್ ಇಯರ್ಸ್ ಅಲ್ಲಿ ಕ್ವಶನ್ಸ್ ಬಂದಿಲ್ಲ, or even it wasn't in news, but still we'll have a basic look at it. So MPLADS question, just like MPLADS there is MLA-LADS also. So MPLADS funds are used to create durable assets, road, health, education ಇವೆಲ್ಲದಕ್ಕೂ ಯೂಸ್ ಮಾಡ್ತಾರೆ. This is correct. Specified portion of each MP fund must benefit SC/ST population. This is correct. ಇದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೂ ಕೂಡ a certain fund is used for the vulnerable section. So ಇದನ್ನ we could have thought of. MPLADS funds are sanctioned on a yearly basis and unused funds cannot be carried forward. MPLADS is a non-lapsable fund. Unlike budget. Budget ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಮಾರ್ಚ್ ರಶ್ ಆಗುತ್ತೆ, ಮಾರ್ಚ್ ಟೈಮಲ್ಲಿ ಎಷ್ಟೇ ಅಮೌಂಟ್ ರಿಮೈನಿಂಗ್ ಇದ್ರೂ ಅದನ್ನು ಫಾಸ್ಟ್ ಆಗಿ ಸ್ಪೆಂಡ್ ಮಾಡ್ತಾರೆ ಗೌರ್ಮೆಂಟ್. ಬಟ್ ಇನ್ ಕೇಸ್ ಆಫ್ MPLADS it is a non-lapsable fund, just like Nirbhaya fund. And the district authority must inspect at least 10% of all the works under implementation every year. This is also correct statement. So in this case, if you do not know about MPLADS in detail, what is that we could have done of? MPLADS ಏನಂತ ಎಲ್ರಿಗೂ ಗೊತ್ತಿರುತ್ತೆ. So statement 1 ಅಂತೂ ಎಲ್ರಿಗೂ ಗೊತ್ತಿರುತ್ತೆ. Specified portion must benefit SC/ST. It isn't a very radical thing, so we could have accepted it as correct. So 1-2-1-2-1-2. MPLADS ಬಗ್ಗೆ ಗೊತ್ತಿರೋ ಎರಡು ಇನ್ಫಾರ್ಮೇಶನ್, ವಾಟ್ ಇಸ್ MPLADS and it is non-lapsable fund, ಇದು ಗೊತ್ತಿರಬೇಕಿತ್ತು. So statement 3 would have become wrong. So 1-2 ಮತ್ತೆ 1-4 ಮಧ್ಯೆ ಚೂಸ್ ಮಾಡಬೇಕಿತ್ತು. ಅವಾಗ 50-50 at least we could have reduced, and that too this is telling that the district authority must inspect at least 10%. So 10% isn't much large. So in that sense also we could have accepted it and marked 1-4 as the right answer. Also couple of other things which I want to tell. See, just like I said, see, it is central sector scheme, it is not central sponsored scheme. Central sector andre it is only the responsibility of the parliament, not of the state governments. So it has been used to promote Swachh Bharat mission, Accessible India mission, all those things. So MPLADS alli the MP will recommend the work, but who will be the implementing body? It is nodal district authority. So district authority must inspect at least 10% of the works. This is also fine. And in MPLADS there will be 5 crore which will be provided in 2 installments, 2.5 crore each, and it is non-lapsable. So MPLADS alli 5 crore irutte each year that MP will recommend for works in his constituency or outside. So Lok Sabha MP, Rajya Sabha MP and the nominative MP, each of these have different jurisdiction. What are those jurisdiction? Lok Sabha MP, he can recommend works only in his constituency, whereas Rajya Sabha MP can recommend works in his state where he has been elected, whereas nominated member can recommend work in the entire country, because nominated member he is nominated, he is not directly appointed from any particular region. So he has been given the freedom that he can recommend works anywhere in the country, whereas when it comes to Lok Sabha, then he does it in his constituency. But Lok Sabha, there is also a provision that even the Lok Sabha person can recommend work outside his constituency, but it should not cross so and so percentage of the funds. Idu kuda one provision ide, right? So MPLADS again basic knowledge irbekittu, that is why we discussed. So this is what, so this was all about the 2020 polity discussion. Polity is a very important subject. So ಈಗ 2020 paper na discuss ಮಾಡಿದೆವು. In the subsequent days we will be discussing 21, 22, 23. ಇವೆಲ್ಲಾನು ನೀವು ನೋಡಿದ್ರೆ you will get a good hang over polity syllabus. And polity is the most important part when it comes to clearing prelims. Economy is second, but polity is the first part. So ಈ ತರನ ಮಿಸ್ ಮಾಡಬೇಡಿ, ಆದಷ್ಟು ಇದ್ರ ಮೇಲೆ ಫೋಕಸ್ ಮಾಡಿ. PYQs ನ ಏನೇ ಕ್ವಶನ್ ರಿಪೀಟ್ ಆಗಲಿ ಅಥವಾ ಸಿಮಿಲರ್ ಥೀಮ್ಸ್ ಬಂದ್ರೆ we cannot afford to make mistake. So with this note I'll conclude the class. Thank you for watching.